Carol spent an afternoon with an attorney 6 years ago, signed her will, put the papers in a filing cabinet, and told her kids where to find it. And she felt good about that. She'd done the responsible thing. When her husband passed away last year, she called a probate attorney expecting a straightforward process. She was right that there would be a process. She was wrong about the straightforward part. 14 months later, the estate is still open. The court and attorney's fees have reached $11,000. And every detail of her husband's estate, what he owned, what he owed, who receives what, is a matter of public record that anyone can look up. Carol had a will. What Carol did not have was a trust. The difference is what this video is about. So let's start with the will, because most people have a rough idea of what it is, but not what it actually does. A will is a legal document that tells the court who gets your property when you die. It names an executor, the person responsible for handling that process. It can name a guardian for minor children. It's an important document. But here's what a will cannot do. It cannot transfer your assets. That has to go through the court. And in Minnesota, that process is called probate. The court validates the will, appoints the executor formally, notifies creditors, settles debts, and eventually authorizes the transfer of assets. From start to finish, that process typically takes anywhere from 12 to 18 months. Court filing fees, attorney's fees, and executor compensation all come out of the estate. And because probate is a court process, the filing becomes public record. That means anyone with a case number can go look up what you owned, who you owed, and who inherited what. Now, that's not a flaw in the will itself. That's how wills are designed to work. A will was never meant to avoid probate. It was designed to work through it. A revocable living trust works differently. When you create a trust, you transfer your assets into the trust while you're still alive. The trust becomes the owner of those assets on paper. You stay in control as the trustee. Nothing changes in your day-to-day life. But when you die, your successor trustee steps in and distributes those assets according to your instructions. No probate court, no public record. In most cases, this process can take weeks and not years. And that's the core distinction. A will goes through probate. A trust, when done correctly, does not. Now, I said when done correctly, and that's where I need to slow down for a moment, because this is the mistake I see most often. A trust only works when it is funded. That means your assets, your house, your bank accounts, your investments, all need to actually be titled in the name of the trust. The trust document itself is just instructions. So if you create a trust and put the document in a drawer but never retitle the assets, those assets still go through probate. The trust cannot protect what it does not own. I see this regularly. A family paid, a few $1,000s for a trust years ago, put the document in a safe and assumed everything was handled. It was not, because nobody moved the assets into the trust. Funding is not automatic. It requires an additional step. And it's one of the most important things to confirm if you already have a trust in place. So which document do you actually need? For most people with straightforward estates, a will combined with the right beneficiary designations on accounts and retirement of funds, well, that handles a great deal. So if your estate is relatively simple, your assets are largely in accounts with named beneficiaries, and probate costs are manageable, a will may be all you need. A trust, however, makes more sense when your estate includes a home or other real estate, particularly if you have a home or property in more than one state, when privacy matters, when you want to avoid the delay and cost of probate, when you're subject to either the state or federal estate tax, when you own a business, or when you have blended family concerns that require more precise control over how assets actually pass. So here's a more practical way to think about which direction fits your situation. If your assets are primarily in retirement accounts and life insurance policies with named beneficiaries, those accounts pass outside of probate entirely. A will handles whatever is left. And for a straightforward estate, that combination can work. However, if you own real estate, particularly a home, a trust is worth a serious look. Real estate generally does not have a beneficiary designation the way an IRA does. Now, Minnesota does allow a transfer on death deed as one option, but a trust gives you much more comprehensive control, and there's potential issues associated with transfer on death deeds, which I've covered in another video. And so without one of those structures in place, real estate goes through probate. If you own property in more than one state, that changes the equation considerably. Without a trust, your family may need to open probate separately in each state. That's more time, more cost, and more complexity for the people you are leaving behind. Blended family situations deserve extra attention. Second marriages, stepchildren, and prior inheritances often require the more precise control a trust can provide. Wills can leave more room for disputes than families expect. Now, there's one more scenario worth naming. If protecting assets from nursing home costs is something you're thinking about, a standard revocable trust does not accomplish that. A revocable trust is still counted as your asset under Medicaid rules. That's a separate planning conversation entirely, and I'll cover it in its own video. Carol, the woman I mentioned at the start, recently called our office. She's looking at getting a trust in place now so the same experience doesn't happen to her children when the time comes. She's also asking about what we call the Save Our Home conversation, the planning that protects a home and savings from long-term care costs down the road. And if you'd like to grab a copy of my book, Save Our Home, you can download it for free from our website. There's a link in the description below. That combination, understanding what you have, making sure it's properly funded, and thinking ahead to the questions that come next, that is exactly what we look at in a planning consultation. So if you'd like to see what this looks like for your situation, the link is in the description below. And if you'd like to discover more, join us in my upcoming masterclass where I'm going to reveal strategies I use with my private clients to help them avoid probate, save on taxes, protect the money they leave for their kids in the event they get divorced, and much more. And you can sign up by clicking the link in the description below. So what question did this raise for you? Drop it in the comments. I read every one. I hope you found this video helpful, and I look forward to seeing you in an upcoming video and the masterclass. Be well.